All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court. Now sitting.
Please be seated. Now that my morning fight with my chair is over, welcome everyone to the courtroom. We're pleased to have you visiting or appearing before the Kansas Supreme Court today. This time, I would like to ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 a.m. docket.
Thank you, Your Honor. The first case on the 9 a.m. docket for Tuesday, September 12th, 2023 is appeal number 125104, State of Kansas versus Taj Anton Anderson, Shawnee County, briefs both sides.
May it please the court, Peter Meharry for Taj Anderson, present and ready for argument.
May it please the court, Michael Sarah appearing on behalf of the state appellee in this matter, present and ready for argument.
Second case is appeal number 124965, Tracy Murray in the estate of Robert Murray versus Miracorp Inc., NTTS Inc., and Lane Goebel and Shane Goebel, Johnson County, briefs both sides.
May it please the court, Stan Bachman for Tracy Murray and the estate of Rob Murray, present and ready for argument.
May it please the court, Ryan Paulus for appellees Miracorp, NTTS Inc., Lane Goebel, Shane Goebel, present and ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. As counsel on case number 1245104, State of Kansas versus Anderson move forward, I might explain to those who are visitors, and please feel free to move forward as I talk. For those who are visiting and may not be familiar with the court processes or who are watching online, I would like to explain that the justices have received briefs and other written materials in these cases. We have read that material and have prepared by looking at the authorities cited by the parties and other things that have helped us understand the arguments that the counsel are making. We now look forward to their oral arguments and our exchange with them. As we do that, you may find us looking at our computers. And I just want to explain that that's because we've taken notes. We may look at case law or statutes, but I want to assure you that what we are doing is looking at things to assist our understanding of the attorney's arguments. We are still engaged in those arguments and are just trying to get the most that we can from our time with the attorneys today and as we consider the cases and the issues. So with that, we'll now call 125104, State v. Anderson.
May it please the court, Peter Meharry for Taj Anderson. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is reserved. Thank you, Mr. Mayor.
Thank you. In this case, my client was convicted of felony murder along with alternative charge of murder 2 and some secondary charges that arose from a killing here in Topeka. The defense at trial was that my client was misidentified, and the 2 main witnesses against my client were bought and paid for by plea deals that the state gave them. Shortly before trial, the Friday before trial started on Monday, the state produced to the defense a recording of my client during a jail call he had with a visitor at jail here in Shawnee. They had not produced it prior to that time. Defense counsel did not know that the state had it and certainly did not know that the state intended to use it. The state found that it was a key piece of evidence because they believed it was what amounted to be a confession to the drug distribution charge, as well as statements from my client that corroborated their theory of the case. And that was that this was a killing because my client was unhappy with the amount of money he was getting in the drug trade. He was unhappy with his share. Defense counsel asked that the district court suppress that and rule that that is inadmissible because of the late disclosure. The court overruled that and allowed that into evidence against my client at trial. We've
Help
argued.
me understand how that, what the basis of the discovery violation is here. Because I know that the parties had a discovery agreement and I don't believe that agreement's in the record. So are you suggesting the basis of the violation is statutory?
Your Honor, we are alleging that it did violate the discovery statute and was not timely disclosed. There was a discovery agreement. Everybody agreed with that. There was no dispute about that. And there certainly was no dispute that this was not produced in line with that. Further, I would point out to the court at the pre-trial, which was in January, mid-January, about another 3 weeks before trial, the state indicated to the court as well as defense counsel that they had produced everything, that there was not going to be anything else in discovery.
So, okay, so the statute allows, it could be disclosure, it could also be inspection. And what I guess I don't understand is, were the calls in general available to the defense to inspect at any point during trial, or was the discovery agreement, did that limit the discovery process to just disclosure?
As far as the calls being provided by the state, just generally speaking, open file policy, stuff like that, the state did not have this, at least the prosecutor did not have this until the week before. The testimony of Detective Regan, I believe I'm pronouncing that right, was that initially when my client was arrested, he did listen to some of his calls, but then that kind of tapered off. But the week before trial, he went back and started listening to him again. And that's when he discovered this call. So the state, the prosecution did not have it because they didn't look. Detective testified, I didn't really go look until the week before trial. So it was only then that it became available to the defense.
Well, it seems then that the foundation of your issue here is that you're imputing what the law enforcement officer knew, or the detective, or I don't remember who it is, to the prosecutor, right? Because the prosecutor, when you look at the plain language of the statute, you know, the prosecution or the prosecutor, they didn't know about it, right? They didn't know about it until the Friday before.
That is what the prosecutor stated, but I would say not necessarily imputing, but the statute says the prosecutor has to disclose things that it knows about and with due diligence would know about. And we've all had cases where jail calls are used against defendants. I've had my fair share. It's usually a nice little treasure trove for the state as far as evidence against defendants.
So it's
So
your
this is-
position in every case, the prosecutor should review all phone calls, even if it's been, the defendant's been in jail for 3 years, that all phone calls, that it is due diligence, that a prosecutor review all phone calls of a defendant?
If they want to use that to convict my client and send him to die in prison, I think they should. And I think they should provide it to the defense.
That's reasonable.
Yes, it is. They are using this to put my client away. If they want to use it, they need to go look for it and they need to disclose it in a timely manner so that my client can review it, analyze it, so as defense counsel can review it and analyze it and properly advise my client.
Did defense counsel ask for a continuance to be able to, because it seems like the only prejudice here was that there was no ability to cross-examine the person on the other end of the phone call?
I think, well, number one, he did not ask for continuance, but I don't believe he has to ask for continuance in this situation. He can certainly ask for the court to suppress the evidence. That's one of the options within the statute. So just because he did not ask for continuance doesn't mean he's somehow waiving this issue. And don't forget, my client was sitting in jail waiting for his day in court. And he should not have to continue to sit in jail because state didn't bother to go look and see if there's any jail calls they wanted to use. So just because he did not ask for continuance doesn't mean that what he did waives the issue as far as asking for the court to suppress.
Is there any harm alleged other than surprise?
The harm alleged by defense counsel was certainly that they did not know that they were going to face this at trial. They could not investigate it. So they were caught off guard. And certainly this was disclosed Friday before the Monday trial. Up until that time, the defense was preparing for trial, not knowing this was going to be part of it. They were preparing with the, as far as their defense based upon what had been disclosed. So I think the surprise that the state was going to use this changed or hampered how defense prepared itself.
Is there any surprise with regard to the recipient of the call? Person who was on the other side of the call?
I believe defense counsel said he did not know who exactly that was, if I remember the record correctly. It was identified as my client's brother at some point. But I believe defense counsel said he could not go out and locate that individual because of the short time period.
Is there any case law to support your position about the due diligence having to review all, having to review all these phone calls?
As far as specifics saying the state has to go back and look at everything, I don't think I have a case and I can point this court to. But I would reiterate, the statute certainly talks about due diligence. And the whole point of discovery statute is for the state to say, hey, we're charging you with X, and this is the evidence we have to prove it. That way the defense can evaluate it, they can investigate it, they can determine how they want to fight it at trial. And that certainly was not the case here because of this late disclosure.
Just one final question, and we're reviewing this for abuse of discretion, correct?
You are reviewing it for abuse of discretion, but I think there's two components to that we've raised in this case. Number one is just standard abuse of discretion. No reasonable person would allow this. But secondarily, we've also said that the district court made an error of law because the district court found that this was already discoverable. And I don't think that comports with the statute. The district court seemed to rule that because the defendant made these statements, it's already discoverable and there's no obligation by the state to produce it. The statute 2232.12 clearly talks about the state's obligation to produce defendant's statements, confessions, etc. So I think that's a misreading of the statute by the district.
Is there any other, following up on Justice Standard's inquiry about continuance, but is there any other cure if we find that there is a discovery violation to this other than suppression? I mean, you're just arguing suppression. That's pretty much the only option the court should have exercised.
Your Honor, I think the court could have continued it. I think the court could have suppressed it. The statute talks about different ways to try cure these problems. Defense counsel asked for the evidence to be suppressed. So that's what we're working on. But I think the court could have said, we're going to continue the case for a week to give you time to look into it. That is one option the court has, but certainly that's not what the court did and certainly not what defense counsel asked here.
I'd like to drill down a little bit into your error of law claim and try to figure out how this statute should work.
Sure.
And we are talking about 3212 subsection A, correct? That's the subsection that you're working from that describes the exercise of due diligence and so on.
Yes.
That provision begins upon request. Prosecuting attorney shall permit defense to inspect, copy, or photograph. Was there a request made in this case?
My understanding, and this was stated in the record, was that there was a standing discovery order. It's not,
But that's different from the statute, right? An order might say something that's
sure
more demanding than the statute, but your claim is under the statute.
My claim is under statute. And my understanding, the way it was talked about below, what there was just a standard discovery order out there that the state produced
Okay,
pursuant to the statute.
So that goes directly to my next question, which is, in your argument, you've described the duty as a duty of production, must produce. I don't see that in the statute. Where are we getting that from the statute? The must produce language.
Your Honor, if they have it, the statute says the attorney shall permit them to review. And I,
Fact copy or photograph.
correct, and that's, I think, a mandatory obligation on the state to allow the defendant to see it. And
On
in-
request.
on request, but if there's a standing request and the state comes up with something,
What was the standing request?
and I don't know because that's not in the record.
Doesn't
They
that
just,
hamstring us pretty badly here?
I don't think so because there's really no dispute that there was a standing discovery order in this case. There's no dispute that this had to be produced under that. The state never said this was different. They just said we didn't have it until the week before trial.
Well, they said they didn't know about it.
Right.
Is there anything in the record that suggests that the defense team was prevented from looking at the reviewing the jailhouse calls?
Your Honor, I don't know what Shawnee County Jail's operations are as far as letting defense counsel look at them. So there's nothing indicating in the record as to whether or not defense counsel could have done that or not. But I think
Doesn't the statute put the onus on the defense to inspect, copy, or photograph?
the evidence the state intends on using. I mean, certainly the defense has an obligation to investigate. But I think the whole point of discovery is for the state to say, this is the stuff we have on your guy. And the defense then has the ability to look at it, investigate it, and determine how to proceed. Otherwise, we're back to trial by ambush. State produces everything the day before trial. Here you go. And I don't think anybody thinks that that gives a defendant a fair trial.
Does the record tell us, I really just can't remember, or if I even saw this, but just let me ask. Does the record tell us whether the detective who came across this recording, had a pile of recordings and then, looked at them periodically, but had them in his possession or her possession? And was just getting around to it, as opposed to went and asked the jail and got it and then suddenly discovered it?
I don't know that the record
See
is,
what I'm asking?
I don't
wonder
know-
whether they were sitting on it.
yeah,
for-
I don't know the record is clear as far as if he had possession, like on a thumb drive or something like that. But his testimony was certainly that when my client was first arrested, he did listen to some jail calls, but then that essentially tapered off over the course of time. And here my client was arrested in May of 2021. The detective said, when that took place, I did look at and listen to some jail calls, and then it tapered off. But then the week before trial, he said he went back. So I don't know if he just goes to, it wasn't said on the record, if he just goes to Shawnee County Jail and says, I need these, or if he has them on his desk. That, like I said, I don't think that's clear in the record.
I'm kind of fishing around the idea that if the state had possession of the tapes, then there was really nothing stopping the defense from asking to inspect everything that's in the state's file, which I'm, you're kind of including the police in that, and I am too. So, what stops the defendant from looking at everything that the police are sitting on?
And I don't know if there's a difference between what the detective had and what the prosecutor had. There seems to be a little bit like there's a difference there from the record. But the way I read the record is what the state was producing, the prosecutor was producing to the defense, what he had access to did not include these. So it was-
There's no allegation that the state sat on this longer than they needed to once they knew about it.
no, that is true. The detective testified he found it sometime the week before. The state said they got it, I think maybe the Wednesday or Thursday, and they produced it that Friday.
So they stumble on it and they give it to you pursuant to their agreement because now they've seen it.
They stumbled on it because they didn't look for it.
So you're arguing for a rule of law that requires them to look for a certain period of time if they want to use evidence against you.
If,
Towards a discovery cutoff that says nothing else comes in.
yes, that's absolutely right, because here, they didn't look until the week before trial. The detective testified, he went back the week before trial. And that's when they started looking. And if they want to use that to send my client to prison for life, that's too late, because my client can't do anything about it.
You're clearly entitled to conversations that your client had with anyone in the jail, from the jail.
I don't know that. I mean, as far as what Shawnee County Jail produces to defense, I don't know. In this case, about all I can tell you is that the defendant certainly seemed to have access to those.
Does it matter? I mean, if you subpoenaed all of your telephone conversation recordings from the jail, is there any possible objection you can think of
Not
to
that I
the
can
jail
think,
producing that?
not that I can think of off the top of my head, Your Honor. But, and I'll just make this one final point, probably reiterating what I've already said. The point of discovery is for the defense to know what the state has. That's the point of discovery, so that they can prepare for trial. Because that did not happen in this case. We believe my client did not get a fair trial, and it warrants reversal by this court.
But the defense isn't confined to that for your own discovery, correct?
They aren't confined to it, but they need to know what the state is going to use.
And it's not the state's obligation to tell the defense everything that they're going to submit at trial, is it?
It's not that they're going to say, we're going to use these 4 exhibits, but they do have to tell the defendant, this is the evidence we have that we could use at trial, that we have against your guy, so that the defense can prepare.
Pursuant to your contract or agreement with the state, correct?
Pursuant to both any discovery order that's in a case, as well as the discovery statutes that we have in the state.
So was a discovery order entered in conjunction and pursuant to the agreement you had with the state?
As far as the discovery order in this case, they talked about it, that there was this discovery order out there, but it's not in the record, Your Honor, so I don't know exactly what it says.
Can I ask you a quick question about your prosecutorial error issue?
Sure.
I'll just tell you where I'm reading the closing argument that you challenge here before us. My first blush is the prosecutor's making an argument, and it looks like it could go one of 2 ways. It could either be improper burden shifting of the burden of proof, or it could be a proper argument about defense having a subpoena power as sort of a rebuttal to the defense's closing argument that there's a lack of corroboration in the state's evidence. And then there's a fairly contemporaneous objection launched by defense counsel, and the district court essentially says, you're coming close to a line, move on, and they do. Why am I wrong? Or it almost seems to me like it got cut off before the argument was fully developed.
Your Honor, we don't believe it got cut off soon enough, because we think the implication that the state made was that, look, if they have something against these 2 witnesses that testified against Toj, they need to bring in something to show why they're lying. We think it already shifted the burden, and the objection didn't cut it off quite in time. And further, I would point out the state didn't, or excuse me, the district court did not sustain the objection or did not cure it. So we think that the impression left is that, yeah, the defense does have that burden to bring in evidence to disprove those 2 witnesses. So that's why we think it does cross the line and was not cured by the objection, because the district court did not sustain it or do anything else. Thank you.
Thank you.
May it please the court. Michael Sarah appearing for the state appellee in this matter. Your Honors, I'd like to address Justice Biles' question initially about the record regarding Detective Riggin and what he testified to regarding the jail call. My review of the record, as I recall, Detective Riggin testified he did initially start reviewing jail calls at the beginning of this case. Fell off.
The call existed that time when he
It
was.
did.
Okay,
It was
so
made.
He, that's what, I couldn't remember exactly when the phone call was made, but it was made kind of contemporaneous with the arrest.
Yes, Judge,
Okay.
the defendant was arrested in Omaha, Nebraska on his federal warrant, transferred to Shawnee County. The call was made 1 or 2 days after he
Okay,
was booked
thank
into
you.
custody. Detective Riggin then testified other cases became a priority. Review of the jail calls became less of one until trial started to ramp up. The week before, he resumed his duties, found this call, immediately disclosed it to the prosecutor, who immediately disclosed it to the defendant. But that is, from my review of the record, that is the sequence of events that how the jail call came to be. Regarding the discovery.
We don't know when law enforcement asked for those calls, do we?
I
from the
believe
record?
Detective Riggin testified he started asking for them the week before trial. The jail calls are stored electronically at the Shawnee County Jail. They're available upon request by either party, is my understanding.
But he had reviewed some initially,
He
right?
had, apparently not this one.
Okay, so, but do we know whether he requested that specific jail call at the outset, or did it?
That I don't know. He didn't testify to that. He just said he began some review of some of the jail calls when the case was new, or the arrest was recent, and then it fell off due to other case priorities.
Is there anything in the record that would describe how the requesting works? Like very practically speaking, if I wanted to listen to a call, do I get like a password and then I just log in, or is there some sort of physical delivery of a thumb drive?
There is nothing in the record, Your Honor. I can tell you how it happens, but it's not part of the record.
But is there a correctional employee that testified that they generally make them available upon request, but
Not in this case, Your Honor. No, the only person who testified regarding the call was Detective Riggin.
Okay.
Regarding Judge Rios's ruling that the call was, he used the word discoverable, but she stated since it was a statement of the defendant, that essentially the defendant knew about it, therefore making it something he had personal knowledge of. I cited to it in my brief at State v. Bancord. Evidence not disclosed to the defendant before trial is not suppressed or withheld by the state, but the defendant has personal knowledge thereof, or if the facts become available to him during the trial, and he is not prejudiced in defending against these new facts. So in order for this to be reversible, Your Honor, I believe there would have to be showing of some prejudice, and the record does not reflect that in this case.
What's your point of citing to that statute again? Is that because the defendant stated was a part of the phone call? It's not discovered. I mean, I don't understand the ruling actually.
I don't like the term the district court used. I believe what the district court was trying to say is your client knew about it, so this
Yeah,
can't be.
it says are fully discoverable.
Yeah.
That didn't make sense. to me.
I think that, like I said, I believe the district court was trying to say your client made this statement. It's not a surprise to him that the statement could be used against him later. That fits with that particular holding in that particular case.
What does the state think that the statute was violated?
I don't believe so, Your Honor. There is an exception. I mean, the discovery obligations, even though the statute says there's a 21-day deadline, they're continuing obligations. The state is not allowed to continue to withhold evidence as it discovers it throughout the pendency of a case. Under KSA 223212I, there is an exception if previously unknown material becomes known to the state or another party that is required to disclose it to the opposition. They are to immediately notify the opposition, notify the court, and disclose as soon as it's practical. So I don't believe the statute was violated because I do believe the state complied with the exception under 3212.
So again, I'm going to ask some similar questions I asked to defense counsel.
Yes, Your Honor.
Defense counsel used the word produce. You've used the word disclose. Where does that, I understand that that's ordinary trial practice. I remember doing it myself. But it's not, that doesn't jive to me with the actual language of the statute. So where does that come from? Is that an extra agreement and order that the district court enters?
Some district courts do enter a separate discovery order, Your Honor. In this case, I believe the only thing that was done, and I could be wrong because I haven't reviewed it that recently, but I think the only thing was the general reciprocal discovery agreement that all the attorneys signed with the district attorney's office saying we're requesting access to your file and permission to inspect and
Wasn't that true in this case, as I understand the arguments?
as far
That,
as.
that the defense counsel had permission to inspect, copy, and photograph all of the jail calls.
I believe that is the case, Your Honor, yes.
But why are we talking about produce and disclose,
I believe because a lot of the way we talk about discovery and outside of the plain statutory language is disclose and produce, because as a general policy, we produce discovery to the defense. We don't say, hey, here's our file, you come get it. I think that's just a general best practice thing. But you're right, the statute says permit inspection.
And the exception that you identified under subsection I, factually, that's exactly what happened here.
I believe so, Your Honor, from my review of the record. As it pertains to the prosecutorial error claim, from my review of opening and closing statements of the defense, a huge portion of the defense was this was a misidentification. This was an incompetent law enforcement investigation. They needed to find somebody. He fit the general description. The defendant's the guy they got to pin it on. The defense pointed out not only the misidentification thing in closing, but also that certain evidence that was available to the state and the state obtained was not produced, and posed the question to the jury, well, why wasn't this? Duong states it's not error for a prosecutor in rebuttal to point out that while the defense is under absolutely no obligation to produce any evidence, they have the ability to do so. And that's exactly what the prosecutor attempted to do here. He was cut off by the district court, but what he stated was not, what he said was not a misstatement of Kansas law. The state is permitted to do that when the defense attacks a case based on misidentification or accuses the state of having evidence they didn't produce with the insinuation that they're hiding something.
But when the language that was used is like, if the defense has a piece of evidence that would show reasonable doubt. So by coupling that, the defense's ability to produce evidence with the notion of reasonable doubt, which, doesn't require any affirmative showing by the defense. Does that make this a little more problematic?
I don't believe so, Your Honor, for a couple of reasons. Number one, I don't recall that. Let me look at
If there's a piece of evidence that would prove or would show that the deaf gets cut off and changes direction, there's a reasonable doubt as to the defendant's guilt. And then essentially they have subpoena power. They can bring in witnesses.
I don't believe it makes it more problematic in this situation, Your Honor, also because the defense in their closing argument told the jury that in order to be convinced beyond a reasonable doubt, they had to be certain as to the exclusion of all other possibilities. I think that defendant's commentary on the certainty, which in my belief is a misstatement of the burden of proof, alleviates any question that the state's use of the words reasonable doubt and saying subpoena power is not prejudicial. And I also still think it is not error. Even if the court considered it error, Your Honor, the evidence in this case was overwhelming. So I believe it's harmless beyond any reasonable doubt if it was found to be error.
Counsel, you mentioned in relation to the prosecutorial error, a case, and I didn't write it down, and I want to make sure. I'm looking at your brief and I'm not seeing that you cited it, and that's why I'm probing here. So maybe I just misheard the name, but I want to make sure I'm looking at it.
I'm mispronouncing it, I'm sure, Your Honor, but it's on page 25 of my brief. It's State v. Duong 292.
Oh, okay, I got it. Thank you.
Can yeah, that's it. Your Honors, I have 5 minutes left.
Yeah, to go back to I want to go back to the first issue and explain to me how the discovery agreement works. And I know you said it's different with different judges that in the district court, but what happened in this case, or can you tell me? Because I know sometimes it's pretty loose from my own recollection of mine, but that was a long time ago. And I don't know if it's been more formalized, because it probably should be, but what is it?
Standard practice from what I understand, Your Honor, and I think this was the situation when you were on the district court bench in Shawnee County as well, was the district attorney's office has a contract essentially saying you're requesting our file, it's open to you for inspection. We will, we, as a general policy, produce it as opposed to having you come in and inspect it unless it's contraband
So
or.
in this case, did it go anything beyond that?
I don't recall, I don't believe
Okay.
so, Your Honor. I know that some judges have a standard practice that they will enter a separate discovery
Right.
order apart from but I don't believe that was done in this case. I could be wrong, but I don't recall seeing that in the record. So the only discovery agreement was the contract between the state and defense.
That contract and then looking at the statute.
Correct.
Okay,
Correct.
thank you.
Okay, so it seems like what it turns on here is when the defense counsel goes in, pursuant to this contract that we don't have in the record, that everything was available, but we're really just talking about right there by the exercise, the information or recorded statement, recorded statements, which are in the possession, custody, or control of the prosecution, which it wasn't, the existence of which is known, or by exercise of due diligence may become known. So really, the issue here is the exercise of due diligence, right?
To a degree, Your Honor, I'd agree with that, yes.
Because you're going in and, and the argument here is you should have exercised due diligence.
And Your Honor and I would agree, in a perfect world, if we had an army of police officers to review jail calls, and there are a lot of them.
Well,
would have been
is
discovered much
the,
earlier.
Let me ask you this, though. I mean, you're conflating police officers and prosecutors. So, I mean, are you talking about one and the same?
Yes.
Because
and
when
no.
you go into the prosecutor's office, do they have everything that the law enforcement officers have?
Not necessarily, Your Honor. Obviously, we don't have drugs, we don't have weapons, we don't have child pornography.
So does the statute cover? Is it the state's position that the statute covers what law enforcement has? Because I couldn't really find a case on that.
Other than Brady violations, Your
Right,
Honor, I
other
can't-
than
I-
Brady
I
violations.
can't either. I don't believe that the statute extends to everything law enforcement may have in their file. I know sometimes district court judges order certain things in a law enforcement file to be disclosed, like field notes or mathematical calculations on accident reconstruction.
But all that is speculation here.
I don't.
Okay.
At
And
this point,
Brady is exculpatory, and in this particular situation, we're talking about inculpatory. So I'm not really. So is it the state's position? What is the state's position on whether or not this statute covers what law enforcement has?
I don't believe the statute extends that far.
and is that because you view the language of the statute and specifically the exercise of due diligence may become known to modify only which are or have been in the possession, custody, or control of the prosecution?
With the exception of Brady material, yes, Your Honor. that
Well,
would be
yeah,
ideal.
I don't want to get too conspiratorial here, but then what's to prevent law enforcement from just holding information until and what happened here? I don't understand why you can't impute for your lead detective what what is in possession of that detective that you're going to use at trial.
If it were exculpatory or potentially useful for impeachment, I agree it would impute. In this situation, it was inculpatory.
So law enforcement can, let's just say, I knew about this. The detective knew about this phone call, but I'm not going to disclose it to the prosecutor until a couple of days before trial. And then the situation happens here. That's not contemplated by the discovery statute?
Your Honor, my response to that would be, I don't want to get too conspiratorial either. I don't believe that police knowingly, with extreme exceptions, look out to withhold information, particularly in a situation like this where the evidence helps the state's case. I do think this was an issue of having a detective having to triage his investigation. As we all know, we're up there, everyone's very busy. Should he, have maybe looked at it sooner, or would that have been more beneficial to all parties? Probably. Does it amount to a discovery violation? I don't believe so.
So I guess the issue here is the due diligence on the part of the prosecutor or on the part of the law enforcement officer? Because that would get rid of the conspiracy, because if the law enforcement officer had it, then the prosecutor upon due diligence would know that.
I mean, that is one way to read that statute, Your Honor, because again, my position is applies to the state as far as the state prosecutor's ability to permit inspection. Now, that being said, I believe there was a question posed by either Justice Wall or Justice Stiegel, or maybe even Your Honor, I don't remember about, couldn't the defense have just asked to listen to these on their own initiative? Because I was a defense attorney for quite a while. I know that jail calls are notoriously bad for the defense because of things people say on jail calls. I don't believe there's anything to show the defense didn't have the ability to inspect on their own.
That's not, but
It
that's
does-
not under the statute.
No, that was one of the.
That's a different.
Yeah.
How far does it go? I mean, what if it's medical records that are inculpatory? State responsible to get the medical records, or does the defense have the obligation to do that him or herself?
Don't know why the defense would go seeking inculpatory evidence other than maybe to try and head off a potential issue client is being accused of. I do think that if I knew something as the prosecution that would be potentially inculpatory, or even, well, the medical records, you never know until you see them, I would go get them myself. But that is just my practice as a prosecutor. I try and be as diligent as I possibly can, given that my have with my caseload, and also trying to abide by my professional obligations.
If we would get to harmlessness, this information was very inculpatory as to the distribution of the controlled substance. Did the state argue that did the state use this to argue anything related to the murder conviction?
I believe they argued for its admission that it was established that it went to motive. I don't recall the state making a huge issue of the jail call with regard to the murder in its case in chief or closing. I think more of that came from the two eyewitnesses, as well as the surveillance footage and the ballistics, and
But wasn't it
And
a
does that-
felony murder?
it was.
Well, was it based on the aggravated robbery or the distribution of controlled substance?
It was based on both.
Well, then, isn't it?
The conviction was for second degree intentional, correct?
Correct. I believe so, Your Honor.
Okay, so they
So
did,
when we get to second degree intentional, how, if it at all, does that evidence weigh in?
Well, Your Honor, as I recall, the allegations were the victim and the defendant were involved in a distribution organization. Victim would give drugs to defendant to sell. He would give money and presumably take a cut after he sold the narcotics. Sometime prior to this, he had been robbed of his stash and his money. Defendant shortly before his murder, not to me, victim shortly before his murder was saying, I need my money. So I think the state's argument was circumstantially because the person on the other call was supposed to be the defendant's brother, but that never really got established. So the defendant's statement was, he was, I recall correctly, I'm not getting my fair share. I'm doing all the work and I'm only getting a little bit of the money. I think that more went to the drug distribution than the murder. Again, I don't recall the state placing a huge emphasis on that being the motive. The motive seemed to be he owed him money, and after he was killed, they took all his, a good portion of his stuff. Your Honors, I'm out of time unless the court has additional questions. Sure. Thank you, Your Honors.
You reserved 2 minutes or 3 minutes. I'm sorry, I can't.
Couple things I did want to clear up. Number one, he was convicted of felony murder. He was charged with felony murder and the alternative first degree premeditated. The district court instructed on both, including then the lesser included of second degree. The jury came back with a conviction for felony murder and second degree. Felony murder, then second degree, then merged at life sentence with a minimum of 620. So it was felony murder, and the statements as far as my client on the phone complaining about his cut of the drug deal was a big part of the stage case. to the murder, not just the distribution. They argued it was a confession that he was involved in distribution, but they also argued it corroborated their theory that this murder was because my client was unhappy with the cut he was getting. So it was a key piece of evidence for the state on the murder charge too.
But would it affect second degree? That's where I'm struggling. I mean, assuming that we have a valid, would we still have a valid second degree? Even if we said it influenced the felony murder?
I don't think you would have that either, Your Honor. I think the state used it to show that this was a murder, not because it shows the motive behind the murder, that this was certainly an intentional murder, according to the state. Not only because mad with his drug cut, but also because it shows that he had talked about it, and certainly this was not something that was. I think it does support both charges, and it was a key point of the state's case. Second thing I did want to point out, I know there's some questions about the discovery order. I just want to quickly point the court to, and this is record 8, page 268. The defense counsel said there was a discovery order, and I put in for discovery. They don't go beyond that. And then also in volume 9, page 478, the defense counsel again says, I had asked for discovery as soon as I got appointed. So there was talk about this discovery order, but they don't go in anything beyond that. The other point I wanted to make was Detective Regan testified he listened to these calls long before trial, but he then kind of tapered off and did other things. No reason why he couldn't continue to do that. I understand everybody's busy, but that's not an excuse. If the state wants to use evidence against my client, they have to timely disclose it.
Guess I kind of want to bore in on that a little bit, going back and rereading your brief during. And the way you frame the error is that there is a discovery violation. And the discovery violation that's cited is 3212 and 3213. Either one of those statutes create the obligation that you're arguing for here. And I'm having real trouble finding a violation of discovery in here. I mean, I understand the fairness thing of somebody coming in and waiving evidence at the last minute. But in terms of a discovery violation, everybody seems to agree the detective didn't come across, wasn't hiding it, didn't come across it. You're saying they weren't diligent enough. Where's the obligation in any of these statutes to be that diligent?
Your Honor, I think when you look at discovery statute 223212, it talks about the existence of which evidence of which is known or by the exercise of due diligence would be known. And that's where the failing is here. They know, the state knows that jail calls, and the state said it to this court today. They're oftentimes great evidence against the defendant. They know about that. Detective Regan was looking at him from the get-go. Shortly after my client was arrested in May of 21, he started listening to the calls because he knew there could be something there. He chose not to continue to do that.
But your argument is not just due diligence, there's jail calls. Your argument is you have to know the substance of the evidence. In other words, everyone knew there were jail calls. It seems to me, there was absolutely nothing preventing the defendant from inspecting, copying, or photographing all the jail calls.
There probably wasn't, but that's not the point of discovery.
Well, but that gets to this disjunction between what you continue to argue is the point of discovery, i.e. the state has an obligation to disclose certain things, not the language of the statute.
The language of the statute says the state shall permit the defendant to inspect, copy, or photograph, et cetera, et cetera.
And it seems like that was met here. The defendant was permitted to do that.
Not in a timely fashion because they did not exercise due diligence.
But
in
what you're
finding-
complaining about is we didn't know the content of the call. That's different from, we didn't know the call, we didn't know about calls at all. We just didn't know we could look at calls. Right?
The defense didn't know the state was going to use this call against my client at trial.
And is there anything in the discovery statute that conditions actions of the state on what they're going to quote unquote use?
I believe so, because the
Where
statute
is that?
says they shall permit the defense to inspect, copy, or photograph all of these things.
But it doesn't talk about what's going to be used in trial.
No, but if they want to use it in trial, they have to allow that inspection. For those reasons, we would ask that this court reverse and remand this matter for a new trial.
Thank you to both counsel for your arguments today. The court will take this matter under advisement. By that, we mean that the court will now later today conference this case and discuss it. A justice will be assigned to write the draft opinion. That opinion will be circulated to the entire court. There will be continuing discussions until a final decision is reached. When that does happen, we will file it. It will be available on our court website, kscourts.org. And there will be a news release that lets everyone know that that decision is available for reading on that website. Thank you, counsel. I will now call 124-965 Tracy Murray and the estate of Robert Murray versus Miracorp Inc. and others.
May it please the court, Stan Bachman for appellants Tracy Murray and the estate of Rob Murray. Your Honor, I would request 2 minutes of rebuttal time.
2 minutes of granted. Thank you.
Your Honor, Your Honors, we are asking for this case to be remanded back to the trial court for a jury trial, so that the finders of fact can determine whether or not injuries that were suffered by my clients were reasonably ascertainable as required by the 2-year statute of limitations. We don't believe they were reasonably ascertainable. And we believe that there's at least there's 3, as we've argued in our pleadings to you. We believe there are 3 issues of first impression before the court that play into the consideration. And so I'll just go right to those. We believe that one of the first things is there a duty to investigate unavailable sources when attempting to reasonably ascertain an actionable injury? The lower courts, including the majority of the appellate court, have relied very heavily upon the statute that allows a stockholder to request an order from the court to review and record and inspect the corporate records. And they've relied upon that as part of the process with regards to whether or not my client investigated, finding that had they in 2011, very important here, had they in 2011 asked for a records inspection order, that they would have discovered all these wrongful acts of Mr. Goebel, and who was the 95% owner and president, director. He ran the company of Miracorp Inc. The reason why 2011 is so important is because in 2011, back to this, we don't believe that having to file a lawsuit to stay within the statute of limitations is reasonable.
We don't believe that it's an available, don't believe it's an available source. We're talking about the discovery rule in particular. And Davidson versus Denning in particular says that we had a duty to reasonably investigate available sources. When there's a fiduciary relationship and a minority stockholder, this court has said in Wolf that the duty to investigate is lesser or it's reduced. So that's another issue we've asked this court to consider as a matter of first impression is what did this court mean when it said when there's a fiduciary duty such as we have here?
Let me drill in a little bit. Try to find a baseline here. You filed your lawsuit in February of 2019, which means you can anybody files, then you can reach back to February of 2017, no problem. What you need, here's the question I've got. Don't you need to get your statute of limitations to reach back all the way to 2011 because that's when the corporation was looted?
There's a couple of ways to answer your question, Your Honor. One is the record is there's a lot of things in the record that show that Mr. Goebel was concealing and hiding a lot of things that happened in 2011. Mr. Goebel was.
I don't care about that. That's what you're going to catch him doing. The point is there anything after the looting of the company in 2011, and just let me use that pejorative, that constitutes a cause of action?
There's yes, Your Honor, every year that goes by, there's continuing, I'll use your words, continual looting.
Corporations, my understanding of the fact was the corporation's gone around 2011, 2012.
Yes, Mr.
The
Goebel.
assets have been moved over to NTTS. And there's no activity anymore because it got looted and all the customers and everything got moved over to this other company. And your client is not a shareholder of that company. So your shareholder is holding 5% of an empty bag as a result of the misconduct, you would allege, of the defendants. So there isn't anything else after 2011, 2012 that you can hang your hat on, is there?
Well, Your Honor, it goes back to being able to determine when the injuries were reasonably ascertainable. Because
But all the injuries are in 2011 and 2012, is all I'm getting at here.
That's correct. They weren't discovered by my client until after the records were produced.
That's fine, but that's where the injuries are. So now we've got to figure out whether it's reasonably ascertainable to get there. The second your client was a shareholder, which was what, 1989?
1989, Your Honor.
He always had the statutory right to ask for, and if necessary, sue for company records, right?
With limitation, Your Honor, the statute that allows for the corporate records says that there has to be a pretty good cause in order to get to the records. You request them, you make a demand for them, as my client did in 2011 and in 2016. But then the court, you have to come forward with sufficient information to prove that you're entitled to the records. The Arctic case that's cited in here says that they don't, that records order for a records request is not a fishing expedition. They don't allow that. You have to come forward with enough information to prove.
Let's concede maybe that there's a hurdle there. Is there anything to indicate that if your client had received the records, that the misconduct would have been disclosed right there? You would have gotten the records, you'd have seen all these assets moving over to NTTS, right?
No, Your Honor, I believe that's the error of the lower courts. That's pure speculation. I believe that's reached far too far because Mr. Goebel was hiding assets at that point in time. The purpose of forming NTTS Inc. was to avoid a $2.5 million judgment that was entered in
Are you
June
saying,
against him.
I'm trying to get at, are you saying that the business records of Miracorp, your client's corporation, would not have disclosed any of this misconduct if you'd have, you have an accountant go look at it and the accountant's going to look at it and not find anything because they're all dummied up?
Your Honor, it's pure speculation as to what Mr. Goble would have produced. And our contention is that by his own,
Records exist. That's not speculation. Can't we go back to 2011 and look at the books, whatever they were?
well, Your Honor, the speculation comes into what would Mr. Goble have produced? Would he have produced the records that showed all of his wrongdoings? We don't think so, based upon his history of wrongful conduct.
If he had, would the records have shown the misconduct?
If he had, we're speculating, Your Honor. We don't know what he would have produced.
Do you know do you know what's in those records?
We finally got some records in late 2017 and 2018.
Or 2011 and 2012?
Yes. Yes, Your Honor. We did get those after we filed in 2016. There was a request for the friend order for the records. And Mr. Goble fought vehemently for a year to not produce those records. So he continued to conceal those records. And finally, some were turned over. And in those records, there's nothing in the record, using the word record here twice, but in the records that were produced, there was only information with regards to Miracorp. There was not any information with regard to NTTS Inc., which was the company he transferred everything to.
Okay, fine. But would the records of Miracorp have shown the misconduct, shown the moving of the assets and the bonuses and and the distributions that you're talking about?
Possibly, if they would have been produced in 2011.
Well, but I'm confused now because I thought you told me you got the 2011 and 2012 records in 2017.
We got some of them, Your Honor, yes.
Okay, the records that you got, did they show
The wrongful conduct?
any wrongful conduct?
No. Not on their face. You would have had to, like you said, you would have had to gotten an accountant to, which we did. We finally got the information and we started reviewing and investigating and found out further what had happened. So the reason we bring up this concealment is we believe that the statute of limitations was told by Mr. Goble's concealment of all these facts and his hiding of all this. We believe that Kansas law is very clear on that when there's fraud or intentional conduct that conceals matters, especially when there's a fiduciary duty. I don't want to lose track of the fact that this court in Wolf, it's an old case, but it's still good law. And in Wolf, this court said that when there's an injury, when the injury has been triggered, triggers a duty to investigate, a reasonable investigation. This court said in Wolf that duty is lesser or is reduced. What did this court mean by that? Compared to, so on the one hand, we've got the fiduciary duties, strict fiduciary duties, this court has said, of the major stockholder and the director of the company, Mr. Goble. He had strict fiduciary duties to tell the minority stockholders what was going on with the company. He was entrusted to take care of the company on behalf of the Murrays, and he did just the opposite. And so he had this strict fiduciary duty to not conceal, to tell them all the material facts. So you have this one duty that's competing with, in this case, it's competing with the duty to do a reasonable investigation by, I'm going to call them, my clients, the innocent stockholders, minority stockholders. And presently what we have is the duty to reasonably investigate, as the lower courts have applied it, at least, has superseded and is being ignored, or rather the strict fiduciary duties are being totally ignored.
Who has the burden of proof? The statute, allows you to ask for the records, which you didn't ask for in 2011, 2012.
No, Your Honor, we did. We did ask for them, but we did not file a petition asking for an order. But on August 22nd of 2011, we did ask for the records. And
Okay, so you got the demand letter.
That's
Okay.
not in the record, though, the August 22nd letter. It's the June letter that's in the record, correct?
No, the August 22nd letter is in the record, Your Honor. It's,
Well,
But here's my
but
question.
the court said they weren't going to consider it, correct?
I
The
don't,
district court said, I'm not going to consider this that's brought in later.
I don't recall that, Your Honor. But I can reference you to the record. It's volume 10, page 282.
But, okay, so you demanded the records, didn't get them. Who has the burden to show what would have been in those records in order to toll the statute of limitations? So we're trying to figure out whether this is reasonably ascertainable. So, you know, you had a statutory right to ask for the business records of the corporation. You do.
Actually, that's not quite correct, right? I mean, you only have the right to ask for the corporate, to see the corporate books, the finances, if you can satisfy a burden of proof of corporate mismanagement, correct?
Yes, and Your Honor, it has to be very specific too. The Arctic case made it very clear that it's not a fishing expedition. So we go back to the Armstrong case, which talks about when a duty to investigate is triggered, right? In Armstrong, we had the mining case where the trespass and Armstrong had heard the explosions, felt the rumble, thought that they were trespassing years before the case was filed, but it got remanded back. And
Did your client in June of 2011 or August of 2011 have anything except a curiosity about the value of his 5% stock and the knowledge that Garmin was using Miracorp's label for something?
absolutely not, Your Honor. And that's taking, we're the movement, obviously, in this motion for summary judgment. And it's in the record that my clients did not know anything about that.
Is
If you
there
look,
anything in the record that indicates whether your client knew whether Miracorp was being paid for that right to from Garmin, or if they were paying Garmin for the advertisement? In other words, did they have any knowledge about whether Miracorp had paid Garmin or if Garmin had paid Miracorp?
the record, there are things in the statute, the statements of facts and so forth in the record that show that there was actually a relationship, a licensing agreement between Miracorp and Garmin. Garmin was paying Miracorp the right to use their search engine, if you will, in the Garmin product. What's in the record, Your Honor, is if you look at, again, this goes back to the triggering, right? What was the triggering event? And what is it that needed to be reasonably investigated? If you look at the August 22nd, 2011 letter, what's in this letter is very specifically, it says that it's for the purposes of determining whether the companies have been mismanaged. That's pretty standard language in these things. And whether other stockholders have received distributions or other benefits from the company that Mr. Murray had not received. That was the limited scope. That was the only thing they knew, that the only thing they suspected was maybe they weren't getting their share of the, of the profits. That was it. There's nothing else in there that talks about triggering all of these other. This letter is August 22nd. In June is when the new company was started and everything transferred over. So this is 2 or 3 months later. There's no indication that my clients in this letter, had they known about the NTTS Inc. Transfer of all the assets and so forth, it would have been in this letter, but it's not.
Is there anything inappropriate about a licensing agreement?
No, there's not.
Is,
It's a good thing. We thought, my client thought it was a good thing. That's why they were curious about the value of their stock.
now, thereafter, they got some K1s, right?
That's correct.
Is there anything alarming about the K1s?
Your Honor, those K1s, first of all, they're a tax form. So good luck. Most people don't even know what they're looking at when they get some kind of a tax return from a corporation.
I couldn't tell anything from looking at them, but
So
I'm asking you.
yeah, so K1, it shows the losses and profits of the corporation, and here's your share. You got to pay taxes or you get a tax credit. What the court probably knows just from common knowledge is you don't get tax returns, you don't file your tax returns until the subsequent years. So in 2011, the 2011 K1 wasn't received until probably sometime in 2012, after the books were closed. The 2012 and 2013 and so forth. And those documents, I think it's a stretch again too far to impugn upon the Murrays, as the lower courts have done, to say there's evidence in these K1s that the assets were transferred just because some assets were disposed of. There might be a lot of explanations why the assets were disposed of. They might be 20, 25-year-old assets that just were no longer any good, old computers that they needed to write off. Who knows if they were exchanged for, for money in kind. So the point is
there anything in the K1s to indicate that everything in the corporation was transferred to NTTS?
not at all. It just says some assets were disposed of.
Showed no business income, right? So all of a sudden, we've got a viable company running since 1989, and in 2012, we've got no business income. That's not a flag.
I don't believe it could be a flag if you knew what you were looking at. I would ask the court to recall what happened in the Phelan case, where the Phelans had actually received this deed and signed it, but it didn't reserve their mineral rights. And this court said that's one piece of evidence that would go to a trier of fact to determine whether or not they could reasonably ascertain their injuries. Just like the deed that the Phelans had in their possession. Yes, my client had the K1s in the possession, but did they read it? Did they even understand it? And what does it even mean? All of this information and all the evidence needs to go before the jury, so the jury can determine as a matter of fact whether the investigation whether it was a triggering event for all of the conversion and all the the 6 tort counts that we have. Was there even a triggering event? And then number two, was it reasonable to expect them to do a corporate records, file a petition? Would it have even resulted in anything, or would Lane Goebel have continued to conceal, and the statute of limitations would have been told?
Well, how would you have met your burden of proof if you had actually filed a petition to look at the corporate books if they objected to it?
That's the point I'm making from Arctic. My client didn't know anything. It would have needed the very records that it would have had to been requesting that were in the control and possession of Lane Goebel, and he was hiding them, or he was concealing them. They needed that information in order for them to have met their burden of proof, to have gotten an order in 2011 from the court to look at the records.
So what broke this case open? What gave you under 6211 a good faith factual basis to assert these claims on behalf of the minority shareholders? Apparently, you say with the assistance of a CPA. What were those records, and when did you actually obtain them?
Your Honor, in 2016, then something else happened. My clients did become aware of the sexual harassment lawsuits that had resulted in the 2011 judgment. In 2016 is when they learned of that. So another law firm, not ours, but another law firm sent the second demand letter in October of 2016, and it's in the record also. And now it talks about and inquires about the sexual harassment lawsuit and the judgment and the satisfaction of that judgment. So it gives us a sufficient basis, at least at that point in time, to ask the court. That was pretty good evidence that something was a foul. And so at least possibly with regards to the sexual harassment and the judgment and satisfaction, how it got paid for, how the judgment that all went before the court. And after a year fighting over that, the judge the district judge finally, what happened was they failed to show up at a hearing and the judge granted and gave him an order to produce the documents. So at that point in time, we got the document, then we got involved in the case and we got the documents and started studying this and did research and did investigations and then we just started uncovering one thing after another, just after another after another. That's why we got 4 amended petitions, is because as we continued to investigate further, we found more stuff.
When was your first petition filed?
But were those, sorry, but can I just nail down?
Yeah.
Sure.
What were those records? Were they like profit and loss statements? Were they a whole slurry of, I mean, I'm just trying to understand the nature of the actual records that you acquired through this,
Mostly-
action to enforce your rights as a shareholder.
It included some bank statements
Okay.
and canceled checks. It certainly wasn't, certainly was not complete in any regard or any manner. It included some financial statements, but not every year and not always complete. And anyhow, those things are not in the record. I'm just trying to answer your honor's question. Yeah, it gave a sketchy picture. And then when we got involved, we started doing some more investigation and discovered this in TTS Inc. And that's it's just so the courts know too, in case you missed that in the briefs. 1989, Miracorp Inc. started, but it always did business as in TTS Inc. Or in TTS, which stands for National Truck and Trailer Services. So even forming the NTTS Inc. in June of 2011 was again a concealment to the public. And Goebel was able to transfer all of his business and continue to do his business with his clients and his customers without their knowledge. They had no idea that there had been a change corporately.
Okay, so just to sum up, the court made its order on October 24th, 2017 to allow the inspection of the corporate records. And then I don't know how long it took for them to do that, but within 2 years after receiving that information, you filed suit, right?
That's correct, Your Honor.
Okay.
We received some documents at the end of off of memory. We definitely filed the lawsuit within 2 years. We got two sets of documents. One was at the very end of 17, I guess it would have been. And then some more came in March of 2018. And of course, then we had to analyze them. So yes, within 2 years, we filed the lawsuit.
I have one quick procedural question, or at least I think it's quick. Aside from ultimate conclusions, like the ultimate conclusion of whether or not something was reasonably ascertainable, ultimate conclusions about duties, is there any actual disputed material fact here in the summary judgment record? As I read it, I don't see one. That's why I'm asking.
Well, I don't think the trial court took into account at all the affidavit of and the statements that were made by Tracy Murray, where she said that they had no idea of all these actions until they got the records. So that was totally avoided. And
Well, but is there an actual factual dispute? In other words, where the parties are saying, this pencil's yellow, no, it's red, an actual factual dispute. I understand the dispute over the ultimate conclusions, but I just don't see a factual dispute, a concrete factual dispute. And I'm wondering if you see one.
Your Honor, I don't think there's a factual dispute as to now looking back with the privilege and the benefit of where we're at today with what we know. It's easy for us to go back and look and I don't think there's any dispute about the facts of what happened.
Okay, that was my question. Thanks.
Well, let me drill down a little bit on that. Now, in the statements of uncontroverted facts back and forth, Miracorp disputes that, or you dispute that Lane Gobel purchased the jet and then Miracorp leased it back from him. That was disputed, correct?
That is disputed, correct. And we believe that he bought that with company funds and he says he bought it. with
Says he
personal
bought it
funds.
himself, right?
Right.
And Miracorp disputes that your client was even a stockholder, right?
Yes, even though they continue even as of last year to send them a K-1 so they can have to pay taxes on something they're not collecting. Yes.
Well, because the statements of uncontroverted fact talk about consideration and that your client, there was no consideration.
Correct. So there's a dispute about ownership, correct?
And then Miracorp, you allege Miracorp bought the jet. And then there's the extent of whether or not your client asked for information from Mr. Gobel or his company, which is denied by Mr. Gobel, correct?
Correct.
So is it material whether or not your client was a stockholder?
Oh, absolutely.
They wouldn't have had the right to ask for records under any circumstance if they weren't a stockholder, right?
That's correct.
And so if the corporation or Mr. Gobel was hiding something from a non-stockholder, it would be irrelevant, wouldn't it?
It'd be a bad thing, but it'd be irrelevant to my clients.
Is there a dispute about whether Miracorp intentionally concealed wrongdoing or misconduct?
Sure there is. We allege that, we allege that, we allege it because we believe a trier of fact with all the evidence under consideration will find the same way. We'll find that, all of the actions that happened in 2011 were intentional. And that NTTS wasn't by accident. It was set up 10 days after he got the judgment, the garnishment.
No, I'm just saying, if for purposes of summary judgment, you know, whether there are no disputes of material fact, I mean, the parties dispute whether or not there was intentional concealment of wrongdoing or misconduct.
Absolutely.
Correct.
That's a disputed fact as well. Yes.
Is there also a dispute about whether there was misappropriation of trade secrets?
Absolutely. Yeah, everything that we have claimed and alleged in our petition is disputed. They've said, you know, not liable, didn't do it. So all of those.
Well, but I mean, not to go to liability, but for intentional concealment of wrongdoing and misconduct, that necessarily goes to the statute of limitations issue, correct?
That's
About
correct.
when something is reasonably ascertainable.
It goes to the reasonably ascertainable. It also goes to the tolling that we're allowed to toll for when there's a fraudulent activity or intentional misconduct.
How long are you claiming that your client should be able to toll the statute of limitations?
Until they got the records. That was the first time that,
Till the court issued the order?
no, not until the court issued the order, because it took a few months to get the records. So even when the order came down, it still took until March of 2018, I believe it was, for those records to be produced. And then they had to be gone through and by us. And so 2018, we filed in 2019 within 2 years.
So your allegation is that you did not receive relevant records to show corporate mismanagement until March of 2018.
That's correct, Your Honor.
So your allegation is that the statute of limitations is told from 2009, 2011 until 2018?
That's correct, Your Honor. We believe it's told because we believe all the actions were fraudulent and intentionally hidden and concealed. So that qualifies, we believe, for the tolling, but we also believe that there was no trigger, that our clients weren't aware of their injuries. There was no trigger for a reasonable investigation. So no trigger, no reasonable investigation was even required. And so from that perspective, they weren't reasonably ascertainable. You can't reasonably ascertain, you can't reasonably figure something out if you don't even know it exists. So for two reasons, we believe that the statute of limitations was told on the one hand, but on the other hand, the injuries weren't reasonably ascertainable until those records were received in 2018.
Thank you.
May it please the court. Ryan Paulus for the appellees. I want to, before I jump into my argument, I just want to address a couple of the questions that the court had for the appellants. First off, when it comes to, there's a question about, were there any records that were provided that would allow the appellants to know that all the assets for the corporation for Miracorp were gotten rid of, were sold. And yes, so they did. And in his affidavit, the appellant states that he received a K-1 from 1989 through, I guess, up to the present, but at least 2012. And if you do actually look at that K-1 from 2011, which was mailed March 13, 2012, it lists every single asset that Miracorp owned: a folding machine, Hallmark trailer, snowplow, Ford truck, office furniture, computer equipment.
That's not unusual though, is it, to sell some of those things and acquire other new things?
Well, it's unusual when it's everything, every asset that they
Does
have.
the K-1 say it's everything?
Well, there's no line that says that's everything, but 13 different things. But to your point, does the K-1 say it's everything? No, but what the K-1 does say is that up through 2011, they had ordinary business income. They would pay Mr. Murray based on the profits that the corporation made. 2012 going forward, there was no more income. And he continued funds, and he saw that. He saw that the company didn't function anymore. The only income Miracorp had coming in from that point going forward was royalties, and royalties that was paid by NTTS Inc. to Miracorp for using one, all their assets that they rented or were disposed of, and then two, for their proprietary trade secret identification of different mechanic shops that service trailers throughout the United States.
So in 2010, he had about $35,000. In
Sounds accurate.
2011, or was that 2011, he had a $15,000 loss. In 2012, he had some royalties. I'm supposed to know that there's corporate mismanagement from that.
What I think that any person would take away from it is that the company ceased to operate as a business. Simply just royalties.
And the timing of those K-1s seem to also align with the requests for inspection of the records demand by the minority shareholders. And they get no response, right?
That's an excellent point. Yeah, so there's two demand letters that came out around 2011 timeframe. Within those demand letters, they laid. Within those demand letters, they said that Rob Murray has been in to see me. He's told me he's a 5% shareholder in Miracorp. No meetings have ever been held. No distributions have been made, and for many other things. And now he sees Garmin using the name and logo. We suggest that you call me. If no one calls me by the close of business Friday, July 29th, I will assume the worst and act accordingly. So you're right, there wasn't a response by Miracorp, nothing in the record anyway. So even based off their lawyer's own letter, and I know this was 2 lawyers ago, but even based off their own letter, the no response was a response, and then he assumed the worst and could act accordingly.
Was there in the summary judgment record evidence that there was a request to inspect records in summer of 2011, roughly?
I believe that the second letter that came after this one, they did ask for an inspection. I know they did in 2016, and then again in October of 2016, and then January of 2017. 2 more demands also asking to inspect the records. but also laying out every single element in the claims that were brought in this lawsuit. So they
Well,
had,
but so, I mean, you can ignore somebody, and is there any indication from this letter or anything else that the Murrays had evidence they could bring to satisfy a preponderance of evidence, which would be required to force you to turn over the records at any time before 2016, when she said she saw the sexual harassment claim? Did they have anything?
well, Your Honor, they had the K-1s that showed all the assets were disposed of. So I think that enough would be allow them to do an inspection, but they don't have to do an inspection.
And those were sent after the letter, right? In June of 2011. After that, they got the K-1s, right?
Well, they got K-1s for every single year since 1989, but the ones in question, yes, were disposing of the assets were received.
So your position is that they also had K-1s, and from that, they should have known that something nefarious was going on in the way of corporate mismanagement.
Well, I don't think anything nefarious is going on in the way of corporate mismanagement,
So they didn't have any evidence of corporate mismanagement, correct?
but they had evidence that the corporation ceased to exist or at least function as a corporation in early.
Let me follow my white rabbit a little bit.
Yes, Your Honor.
Whole. What's your view of shareholder rights under 1765? Shareholder production statute. You know, the shareholder makes a demand for the books and records of the corporation and stock stuff. What can any shareholder do under that statutory thing? Because plaintiffs had that statutory right to ask for the corporate records under 1765-10, right?
Yes, Your Honor.
So just walk through the process. As I'm reading the statute, I don't see a burden of anything other than they have to prove that they're a shareholder, which might have been in dispute, but won that fight, then we don't have this lawsuit.
Yes, Your Honor.
But so they have to show that they've got that. They have to show a proper purpose, but that's not defined here. But then it says if the corporation refuses, they have to prove that the shareholder is asking for a improper purpose is all I'm seeing here. So what's your view of how this statute operates? What rights did the plaintiffs have as shareholders to be able to look at the books and records of this company at any time?
Assuming that he was a valid shareholder, then yes, at any time, those records should have been turned over there. I think it's actually a minimal standard to me, simply that you are a shareholder, so you have access to the records of the company.
And you contested that, didn't you? In the summary judgment motion and responses in the uncontroverted facts, you issued that you denied that there was any consideration paid for Murray's stock, correct?
I'm really glad you brought that up, Your Honor. So we do not contest the facts that underlie it. I don't think there are any facts in dispute in this case. We contest the conclusion drawn from those facts. Ultimate conclusion. So are there defenses to him being a shareholder? Absolutely. He didn't provide information. He fraud, but those are defenses. Not an argument to the facts of what occurred.
But that's certainly a reason to refuse to let somebody look at the books, right? If you contest whether they're a shareholder, because only shareholders have the right to look at a book,
Certainly,
at the
Your Honor.
books.
Do we have in the record business records of the corporation from the 2011-2012 timeframe?
So the records that were produced from the court in the action to affect the records.
I just need what's in this record here, and I don't remember.
Or they're not. So what is in the record are the tax filings. That's another good point. So you ask appellants whether or not the documents that they believe or led them to bring the lawsuit were received. The lawsuit was filed within 2 years of that. They weren't. So the records were actually received in October of 2017, and this case was brought. Well, I'm sorry, it's either October or December of 2017. To make sure I'm accurate, and this lawsuit was brought February 7th, 2019. So
Is that date in the record? Because I'm reading from the Court of Appeals decision. It said that the district court ordered them produced on October 24th, 2017. So what is the date in the record that you produced them?
oh, okay, so thank you. So the order for the court ordered them, and then is it that in the record in this case? No, it's not. What we had to do is we had to look at the record from the previous case. File their certificate of service for providing the records, and that would.
But that's not in this record? What?
I'm sorry, can you clarify the question?
You're saying that they didn't file the lawsuit within 2 years of receiving the information?
Yeah.
After the district court, you said that you sent the records in December of 2017. And I'm just wondering what the record site is for that date.
Okay, I mean, there won't be, it wasn't me, of course, it was a different one at that time too, but all courts can take judicial notice of filings within. I mean, so was it attached to summary judgment? No.
I'm confused about this because if they filed suit in February of 2019, they're within 2 years of a December 2017 production of corporate
Right.
records.
That would be December 19. And if they filed it-
You'd get till December of 2019 to,
Right.
Oh,
if that's your launch date.
yeah, I apologize then, I must have messed up my dates from when it got filed. Yeah, I must mess that up. I apologize, but either here-
Regardless, are the records that were produced in late 2017, not worrying about a date, are those in the record?
no, they're not, Your Honor.
And so when you say the tax records, are we just talking the K-1s?
Yes, Your Honor, the K-1 filings, I think. it was-
Nothing beyond that?
No. And I guess the other thing that I want to address with the court in my last couple of minutes here is whether or not we're kind of putting the horse ahead of the cart. So we're trying to analyze whether or not but their argument is based on or premised on the belief that there were factual disputes regarding when the injury occurred, and what they knew or when they should have known it. But if we look at the demand letters from 2016, 2017, even back to 2011, they lay out all the claims that were brought in this lawsuit with those demand letters. So obviously they already had knowledge of it. So we don't have to guess when they could have figured things out because we know.
Aren't you presuming that? Aren't you presuming they had knowledge of some type of inappropriate behavior?
I'm just basing it off the words that their lawyer put in their demand letter that mirror the claims that we have in this case, outlining the allegations of harm that they brought.
Does 6211 come into play here at all, though? I mean, it's one thing to make an allegation that you maybe suspect the very issues that later become the factual basis of a lawsuit, but to have a good faith basis, in fact, to assert those claims in a pleading that is signed, which under 211, you have to then represent that you have a factual basis for those claims. Do you see the distinction or potential distinction between those two?
I do, Your Honor. I see where you're coming from there, but everything that they based, like the sexual harassment lawsuit, who paid for those settlements, where none of that stuff is contained in the records anywhere, or it's not part of the file in front of this court. They knew what happened, they know those payments came out, but the records didn't change. You know, there was no smoking gun in there where they said, oh, look, Miracorp, which wasn't even existent, didn't pay for anything, but NTTS paid for it as opposed to Lane Gobel or Shane Gobel. I see I'm out of time. If there are any other questions. Thank you.
Your Honors, I would draw your attention to some of the questions. This is the case that Your Honor, you asked about reading of the statute with regards to the request for the records. This court in Arctic versus OTR spoke about and expounded upon the requirements, and that in that case, this court said, we don't allow fishing expeditions. You have to come forward. The first thing you do per that statute, Your Honor, is you have to make a demand, and you have to specify why you have a right. I mean, it includes, you have to show that underneath an affidavit that you're a stock owner. But you also have to come forward with something that's firm. And then in order to get the order, you actually have to meet your burden of proof that you have a right to the information that you're asking for. And Arctic does a really good job of pointing that out. And so I would draw your attention to the Arctic
How do you
case.
get around the Lathrop and Gage letter on behalf of your clients and the August 2011 letter where they talk about want to examine the books and records of the corporation for the purpose of determining whether the company has been mismanaged and whether other stockholders have received distributions or benefits from the company that he has not received? That seems to be some awareness of something wrong.
I would agree, Your Honor. The August 22nd letter pinpoints what they think something might be wrong and is speculation on their behalf. They wonder, are other stockholders getting something we're not getting? And that's the only thing that they're really, that may be the only thing that I'll say was a trigger. All the other actions though, that we've asked for, conversion and unjust enrichment, all those things, there's absolutely nothing in the record. The August 2011 letter does not speak whatsoever at all to the conversion of all the assets or the unjust enrichment or the fraud or the.
We talked about distributions that other guys got that I didn't.
Yeah,
That seems like
that might be part of the fraud claim, but it's very specific. It doesn't talk of, there's no mention of NTTS Inc.
I understand.
Your Honor,
that.
if they would,
The issue for us is whether reasonably ascertainable that something is amiss. Corporation. And so at least by August of 2011, we know that your clients, through their lawyer, have suspicions at least of the company being mismanaged. That's pretty broad. I think that would cover most any kind of corporate malfeasance. And then whether other stockholders have received distributions or other benefits that he hasn't received. That's a fairly broad bit of information that they've got. Now, in analyzing whether it's reasonably ascertainable, there may be other dots to connect, but it seems to me that somebody says there's a smelly fish here in the bucket and we need to figure out why it smells.
but mere suspicion's not enough, because as Arctic points out, you have to come forward. You can't do a fishing expedition. You have to come forward and prove that you're entitled for the order. And
That's a different fight
it's
than knowing that there's a problem. So
But
now I'm just saying, we know there's a problem. We know we ought to use these statutory rights to try to pursue it. And we've got this demand letter, but we're not doing anything, and then they ignore it. I mean, that'd make me run to the courthouse.
But if you run to the courthouse, Your Honor, you're not going to get an order. Because, you know, you have no evidence. All the evidence is in the records that Mr. Goebel's holding. So we have nothing. We have no way of getting the order from the court. Yes, we made a demand based upon some suspicions that we weren't getting distributions possibly, but that was mere speculation. In order to get the order, it would have been futile for us to go to the court. We had no evidence. In 2011, we knew nothing. We had no evidence to take to the court and say we were entitled to an order to inspect the records.
But now we're still gonna, after this letter, we're still gonna sit on our hands for 8 years before we file a lawsuit. And so figuring that out is the task, I think.
And Your Honor, I would say, look at Armstrong and Phelan. They go hand in hand. There has to be a trigger. In order for that duty to investigate to start, there first has to be a trigger. There has to be a shaking of the earth. There has to be something that puts you on notice that you better do a reasonable investigation. And there's no trigger. We didn't know anything. There was
So are
absolutely
you
no trigger.
claiming that the August letter is just a bluff?
It's not a bluff. It's a suspicion. We want to know. I didn't write the letter, but on its face, it looks like we're saying, hey, in August, we're saying, we want to know if we've already said we knew about the tie with Garmin. We just want to know if we're not getting what we're supposed to be getting.
So a hey, I wonder is different from I have facts to show
Correct.
something is going on.
That letter doesn't say that we have any facts. Those facts are in the records that we needed to get, and we couldn't have gotten them because we didn't have the evidence to go to the court and get the order.
Questions?
Thank you.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. We will now be in recess until 11:05. All right.